Hi, I'm Carmen Ramirez, Community Director here at Pacific Workers, the Lawyers for Injured Workers. Every month, Bilal Kassem and I have been hosting a free live webinar where we educate injured workers on their rights, we provide amazing tips, and most importantly, we answer all the questions that most injured workers have here in California. I want to invite you to join us to these free live webinars once a month, which, by the way, our next one is coming up on August 27th at 12 p.m. Don't miss it. Take your lunchtime, go ahead and indulge yourself into this webinar and educate yourself on the rights you have as an injured worker. Secondly, we've decided to break this webinar because there's just a ton of information provided in here that is very valuable. In this first part of the webinar, we're going to be talking about denials, why they happen, who's involved in regards to making decisions regarding denials, and what you can do about it. Yes, you have options, you have rights, and Bilal really has this clear way of explaining how you can handle denials. Not only that, denials doesn't mean that your case is over. It just means that you're starting the beginning of your case and your fight. Therefore, I want to invite you to not miss this first part of our series of this webinar we have for you. Thank you for watching. Don't forget to subscribe and hit the bell notification so you get notified every time we upload new content. And most importantly, if you know someone that is also struggling with the workers' comp system or who's been injured at work, go ahead and share this information with them. That way they too know their rights and how to properly manage their workers' comp claim. Best of luck, and I hope you enjoy our first part of this webinar.
Today's topic is for those that are fighting the system. The word fighting sounds a lot stronger than what a lot of people want to actually say. But luckily for us, there's just so much that we are going to uncover and unfold in this webinar. So, Bilal, how are you? Welcome.
I'm good. Happy to be here as always.
It is a pleasure to have you here. I love being able to pick on your brain, asking you questions, and being able to educate the injured workers, which is like our number one priority.
It's a blessing to be able to have this time and opportunity to give back and offer people advice and hopefully guide them in the right way, you know?
There is something really important that I do want to share for those that are joining us in this live webinar, and it's explaining the basics, right? If you're new to the workers' comp system, it's a scary situation. If you've ever been denied medical treatment or even just in general, the benefits that you are entitled to and that you desperately need as an injured worker, it sucks. Just thinking about it, that you're going to go and have to jump through loopholes and stuff. So people think that just because that is their first come, first serve basis on the system of the workers' comp here in California, that's it, that there are no options. I just flat out got denied, or the doctor is going a different route, not really listening to me, or my boss is just being really rude after I got injured. People give up and just think that that is the actual norm. And it's not. That's exactly what the system wants you to believe. And that's why we're going to have this conversation to share with you some of the things that are not being told. Of course, the insurance companies are not going to share this with you. They're not going to be like, oh yeah, by the way, we don't want you to know, or we want you to know X, Y, and Z. And that's why we wanted to do this webinar, to really break some secrets that we know from being able to be in the system and helping injured workers for so many years. There's things that you just know that it only comes to you when you've been involved in numerous amount of cases, right? And in this case, in the positive side. I want to be able to explain to those that are here for the first time below, like a little bit about your background. Tell me about some of the frustrations, why you chose this part of the law. And yeah, we can start with that.
Sure. So I used to actually work for a personal injury and workers' compensation law firm that represented people injured at work back when I was in college. And it was just a job at the time. I don't think I really appreciated the subject matter at all. As a receptionist, I got a feel for what it was about, but not really. It wasn't my job as a lawyer at the time or a paralegal or anything like that. And I went off to law school after that. And I thought, I'll probably never see this kind of area of law again. And then sure enough, after law school, I got into representing insurance companies and employers, largely just on the employment law side of things. I represented employers that were accused of depriving people of overtime, not giving them meal periods, misclassifying them as independent contractors, all that nasty stuff. And it was through that I started representing insurance companies for also related claims like disability discrimination, serious and willful misconduct, and also 113 32A claims. And then that led me into doing a lot of workers' compensation insurance defense, which my primary responsibility was saving the insurance company's money. I got to see what it was like on their side of things. I saw things like fraud. I did see stuff like that. I saw some bad cases that came through. People were making up injuries and stuff. But for the most part, what I saw was the idea that the primary responsibility of the insurance company is to its shareholders, not the insured, not the injured worker. The whole idea behind insurance is to create a profitable financial company that takes in more money in insurance premiums that it pays out in claims. That's the driving motivator behind an insurance company. And essentially that creates this heartless environment where the insurance companies and their agents, meaning their employees, are entirely driven by the idea of saving money, denying claims, limiting responsibility. And it was through that process that I ultimately kind of saw the light, so to speak, and I saw what was happening to people, and I decided I didn't want to do that kind of work anymore.
You changed to the good side.
Yeah, there was a case in particular. A gentleman had fallen off a ladder. He had smacked his head on the concrete. So he suffered a traumatic brain injury. He was really messed up. And I represented the homeowner's insurance policy, and there was a dispute about whether we had coverage. And I won the case for my client. So my client was off the hook for any responsibility for this gentleman's injury. The insurance adjuster was rightfully very happy and is super proud of me. And, oh, I want to send you more business and blah, 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 blah. And that just didn't feel good. A win was seeing someone suffer and having to delay benefits and responsibility even longer than it already was. And so, that was a really defining moment that forced me to actually make a major change. And so it was after that I decided to start representing injured workers.
Man, well, we're glad that you switched the sides because honestly, I can't sit here and be like, hey, I'm proud to say that I stripped away the rights of someone who got injured in regards to medical treatment. And I'm going to celebrate this. Like, I'm going to pop a bottle of champagne and celebrate that I saved my company thousands while there's someone who was injured and probably won't have the amount of money that is needed for any type of surgeries or anything ongoing medical treatment they might need. So we're happy to have you on the good side. There's also a quote out there, and it's a fact more than anything that I kind of want to demystify. I want to see, is this true? Is this just what people say? Or is it factual? Is it for real? Does this really actually happen? And as someone who's fought for the rights of injured workers that, again, have been stripped away from the insurance companies and everything has been taken away from them time after time, is it true that people with the most serious cases often get the least support? Unless obviously you know how to run the system. But is that a true fact?
Every case is different. And I had catastrophic cases that are just flat out denied, people with multiple gunshot wounds or people with amputations and things like that. And I've seen those cases just flat out get zero, get zero attention, get zero love. I've also seen cases that are rather minimal where a person gets everything they want and more. There's a lot of variables that go into a workers' compensation case, who the doctors are involved, the adjuster, who the insurance company is, the defense attorney that may or may not be assigned to the case. And I think each case is looked at individually and differently, and no two cases are alike. You can have the same exact set of facts, but different parties involved, and you'll have a completely different outcome every single time. So I'd say it really just depends on what's going on in the case and who's involved with it.
There is a really big misunderstanding that when people get injured, Bilal, or they get denied of a case when they get injured, that if you get an attorney, things are going to slow down. I think a lot of people believe like, oh, it's just going to complicate things. It's going to be expensive, but it's the total opposite. In my opinion, I think that realizing that the knowledge that these attorneys, whether it's you or whether it's a whole entire legal team, that the experience that they have within the workers' comp system, it's going to help you fight all the loopholes that you're going to be thrown into within the system. Our plan for today's webinar is to obviously give the people and educate everyone who's watching this, or if you know someone who's been injured and needs to hear this, just the right information to take control of your life. Tell me a little bit about what you've recovered with your team, Bilal, in regards to Pacific workers.
I've been a lawyer since 2011 now, so 14 years, going on 15 years, primarily handling workers' compensation cases, primarily for injured workers. And throughout that time, me and my firm have recovered $350 million in settlements where we've taken that money from insurance companies and redistributed it to people in need. Throughout that time, we've handled cases that, are worth $1,000 to millions and millions of dollars and everything in between. I think the common denominator we see in all cases is that people are treated the same way by the insurance company, regardless of how significant their injuries are. And we've seen that need. And so a lot of times, I think a lot of people can feel like getting a lawyer may not be necessary because maybe they think their case is too small, it's not significant enough. And from our perspective, how much the case is worth does not matter. We see people who are being taken advantage of and deprived of what they're legally entitled to by the insurance companies. It doesn't matter if it's $50, it doesn't matter if it's 5 million. Everyone needs help. And we've taken that approach to how we handle our cases, how we staff our cases, and the care and attention that we give to the clients. Really everyone's kind of in the same boat. Some cases require more attention than others, but ultimately I think the concern that people have that a lawyer will slow things down is kind of the opposite. You may think your case is running smoothly, but it's only because you don't know what you're missing. And we see a lot of that in a lot of cases. People who come to us with very, very low settlement offers from the insurance companies where we've tripled or quadrupled what the insurance company was offering them, sometimes more. We've taken cases that were worth zero and turned them into multi-million-dollar cases and everything in between. We've really seen kind of everything at this point. I think we've had over 10,000 clients for all sorts of injuries, whatever body parts and systems you can think of all over the state of California. We've seen and done it all.
Well, I'm glad that I have that as a background because the questions that I'm going to ask you now are going to make more sense as to why you answer them the way you do and the authority that and the confidence that we can say, hey, we've been there, we've handled it, we've done that as a team as well, right? So I'm glad you brought up the whole aspect of the settlements. When people get offered zero money and you turn those into sometimes multi-million-dollar settlements. And I think that also comes hand in hand with the fact that a lot of people believe that that is the only option they have. Like if a doctor tells you, yeah, you're not going to heal anymore, that's it, you've reached the end of your recovery, you're going to believe it because you're trusting the doctor. You're not the doctor. You're letting the doctor diagnose you and give you their medical opinion, right? It's the same thing for workers' comp. You don't know the system, the law as well as you think. You can Google it as much as you want. You can YouTube it as much as you want. You can watch work comp talk videos, hint, hint, and also check out the podcast as often as you want. But you truly won't know what the roadmap to your specific injury is going to be until you sit down with an attorney and say, what am I looking at? What are my options? One of the biggest setbacks, I would say, is when people get denied. So that is why we're going to share the first secret of some of the things that the insurance company does not want you to know when it comes to denials. Number one, it's very important for you to know that a denial is just the beginning of your fight. It doesn't mean that it ends there. It doesn't mean that you're just flat out not going to get anything. Like that just means you're barely starting to get to the point where you need to get into action mode and fight for your rights. So Bilal, I did wanted to ask you about this pain point that happens a lot in a workers' comp claim. When people get denied, what are some of the things, what are some of the steps that you can share with us to let people know that if the insurance company tells you, oh, there's nothing you can appeal, but we're still going to deny. Let's get them out of that mindset and teach them what is the process they can do when they get denied.
So there could be a variety of reasons why a case is denied. They really fall into three buckets. It's either a medical justification, factual justification, or a legal justification. And largely what you do when you get a denial is going to be dependent on which one of those categories your case falls into. Some can be more complex to deal with than others. Others are relatively straightforward. I think the most common one we see is medical-based denial, meaning a denial because the doctor had said your injury was not work-related, that you don't need any more care, that you don't have any permanent disability, things like that. Which are very common. That's largely in part because the insurance company has medical control over your case in the very beginning, which means they get to send you to the doctor that they'd like to send you to, which, or surprise, surprise, is always going to be an insurance-oriented clinic who really doesn't look out for the injured worker as much as they do the insurance company. And that's really because they are financially incentivized to stay within the insurance company's good graces so that they can continue to get the referrals from the insurance companies as their preferred medical provider for industrial claims. So, we see a lot of people who come to us with legitimate injuries, legitimate problems, and they get this report from their doctor, Concentra, and it says your injury is not work related. You say you have back problems. It's not because you've been a construction worker for 20 years. It's genetic, it's degenerative disc disease in your back. It has nothing to do with your hard labor over the last decade or two. Something we see really common. In those cases, you have the option to actually elect to see another doctor, a QME, to challenge your primary treating physician's findings.
Would this be considered like your typical second opinion? Like one doctor told you something, now you're going in for a second opinion, and this is going to be with a different doctor. doctor?
In a sense, actually just, I think, recorded a great podcast on this episode. So if you're interested in learning more about that, you should definitely dive in. I don't want to be too hyper technical, but there are ways where you can seek second opinions without necessarily going to what's called a qualified medical evaluator. That's a bit more hyper technical. I'd say the main idea of a second opinion in some sense is the QME. When there's a disagreement about a treating physician's finding of injury or, disability status, work restrictions, permanent disability, those things get resolved by going to a QME, or if you have a lawyer, an AME. But that doctor serves as the second opinion, basically, a second shot to say, hey, did this treating physician get it wrong or did they get it right? And so every injured worker has that option. They always have the right to a QME. You never have to rely on just what your primary treating physician tells you, especially the primary treating physician that was assigned to you by the insurance company.
Yeah. So to summarize this, if you've been denied, one step would be, okay, if my primary doctor denied me X, Y, and Z, I can then go to the QME, qualified medical evaluator, or agreed medical evaluator if you are already obtaining legal services by another attorney or by us. So then I get to go to this. What about the URs, the utilization reviews? Where does this come into play?
So a little bit in a different vein from the QME process, you may have a treating physician and they can be totally on your side. It has nothing to do with the fact that they're prematurely discharging you from care, that they don't agree that you got a work-related injury. They could be batting entirely for you. And the issue we run into a lot in workers' comp is the idea that your doctor may want to do certain things for you. They may want to provide treatment, but their hands are tied because of this process called utilization review, which is this process by which the insurance company gets to essentially say yes or no to requests made by your treating physician for treatment. So your doctor can say, I want to prescribe you Tylenol, or I want to prescribe you something more significant, muscle relaxants, things like that. They may want to do injections or request authorization for, surgery. And at the end of the day, this process called utilization review, called UR for short, is essentially is created initially as a guardrail to ensure that only reasonable and necessary medical treatment was being provided, to make sure doctors weren't saying everyone needs surgery when they really don't, things like that. But what's happened is utilization review more often than not actually denies the request for authorization. And if utilization review denies request for authorization, the doctor doesn't mean the doctor can't provide it to you. It means they're not going to get paid for it. And obviously these doctors can't give treatment for free. And so essentially they're in a position where they provide you treatment that wasn't authorized, they don't get paid. So they in essence don't provide it for you. So really it boils down to, unless utilization review says yes, the care that's being requested isn't going to be provided. There is a second appeals process called IMR for that, but really in practical terms, it's not much better. I couldn't tell you exactly what percentage of treatment is actually denied by utilization review. It's more likely than not, I would say, 70% or something really crazy. And then the IMR appeals process, that has to have like a 8% success rate or something like that. I gone to a conference in San Diego several years ago where they audited kind of the amount of times injured workers appeal treatment denials and how often their appeals are successful. And it was like a fraction. It was so small.
That is so sad.
Yeah.
So sad. And mind you, this is only like one part of a process within the system itself, right? We're talking about the times when you get flat out denied, whether, it's for medical reasons or because they don't believe what you're saying or just legal reasons that you probably missed your deadlines and stuff. So breaking this down to make injured workers understand that just because you're flat out denied does not mean you get the end of the road. If anything, this is just the beginning of a battle that you're going to go into to continue to fight for your rights.
Well, that wraps up part 1 of our webinar series where we discussed everything about denials. I hope you learned a lot of stuff in this. And in part number 2, get ready because we're going to dive deeper into these denials. We're going to talk about what makes or breaks your case, and not to mention, yes, how not all insurance doctors are on your side. And there is a big myth that happens in workers' comp that a lot of injured workers fall into. And that's believing that when you open or file a claim within your workers' compensation system, that you're suing your boss. We're going to be talking all about that in our second part of this webinar series. So don't miss out. You're going to catch that pretty soon here on our YouTube channel.